All persons having business before the Honorable Associate Judges now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Good afternoon, everybody, and welcome to the District of Columbia Court of Appeals remote oral argument courtroom. We have one case on this afternoon's calendar, and that is Fallon versus United States. It's number 19-CM-233. And we'll hear now from the parties if they are ready. Ms. Wang, you may proceed.
Good afternoon. May it please the court. Alice Wang on behalf of appellant Ronte Fallon. I intend to reserve 3 minutes for rebuttal. The jury trial issue in this case involves two questions. First, whether the sex offender registration and community notification requirements of SORA count as a penalty for purposes of the Blanton analysis. And second, whether the severity of that penalty, when combined with a maximum prison term of 180 days, reflects a legislative determination that misdemeanor sexual abuse of a minor is a serious offense. On the first question, Badeau held that a statutory consequence of conviction does not have to be intended as a punishment to count as a penalty within the meaning of Blanton. That holding substantially undermines the philosophical basis of Thomas. It also forecloses the government's argument here that SORA does not impose a penalty because its purpose is to protect public safety rather than to punish the defendant. Under Blanton and Badeau, even non-punitive statutory consequences of conviction, like deportation and revocation of a driver's license, count toward the Blanton analysis. And sex offender registration is no different. It is a penalty because it is an adverse statutory consequence automatically triggered by a conviction. On the second question in the Blanton analysis is whether the severity of the penalty reflects a legislative determination that the offense is serious. And the answer to that question is yes, for two reasons. First, as this court has recognized, SORA's requirements are tied to the severity of the offense, with more onerous requirements attached to more serious crimes. The legislature's decision to classify misdemeanor sexual abuse of a minor as a Class B offense, which requires 10 years of registration and internet notification, is objective evidence that the legislature views that offense as on par with other Class B offenses, all of which carry at least 5 years in prison and are unquestionably serious for purposes of the jury trial guarantee.
Counsel, is that essential in your view to your argument? So imagine that weren't true. And so really you were relying solely on the practical consequences of sex offender registration. Would you have the same argument? So that's supportive of your view, but not essential in your view?
That's right. It's supportive, but not essential. There are two, as I mentioned, we think there are two reasons why the severity of the penalty reflects the seriousness of the offense. That's the first one, that we think that's objective evidence of the legislature's determination that this type of crime is serious. The second reason is that the practical—
Can I ask you, I'm sorry to interrupt, just to flip and ask you the other way around. Imagine that really all of the petty offenses measured by incarceration in the District of Columbia local court system, imagine all of them had a 1-year period of probation. And then imagine that the DC Council, as to one of them, said, you know what, we're going to impose a 5-year term of probation. And every other offense that had a 5-year term of probation was a felony of some kind. Would you say that that being so, the conclusion would follow that this offense becomes non-petty for purposes of the Sixth Amendment jury trial right, because the legislature chose to throw it into an area of overall punishment that the legislature has reserved for offenses that seem serious, all the other offenses which seem serious?
I think that if the purpose of that statute is to reflect the seriousness of the offense, if it's clear from that statute that increases the probation term for that particular offense, that that, this is such a serious offense that we're going to increase the term of probation, then that would be strong evidence that the legislature views that as serious. And I think that would distinguish the case from, Frank.
Right. So my question is, I guess, leaving aside whether it's strong evidence, would you think it is sufficiently strong that if that's the only, in other words, if this is exactly like a Frank's kind of case, except there is the point that the legislature, for all of the other petty offenses, had 1 year of probation, and let's say, this is consistent with one thing you were saying, imagine the legislative history of the amendment increasing the period of probation to 5 years said, we do this because we think it's a particularly serious offense. You would say non-petty offense, even though the objective impact of the punishment on the offender measured absolutely is the same as it was in a case like Frank.
Yes, because Blanton says that you look to objective indications of the seriousness with which society regards the offense. And it says that the most relevant of those indications is the severity of the maximum penalty, but it doesn't say it's the only indication.
I thought that when Blanton was talking about objective indicators, it was saying we don't want judges coming to their own subjective determination of whether an offense is, quote, serious. We're going to look at what's in statutes. In other words, we're looking to see how society views a crime. We view the legislature as kind of proxy for society, right? Elected representatives. And what they say in legislation, what they say formally and officially, that's what we look at. Isn't that what the objective is?
Yes. And I think that the evidence, the hypothetical that Judge posits is such objective evidence. It is not just judges saying, oh, well, I think this offense is really serious because it's so morally repugnant, et cetera. It is actually looking to what the legislature is doing and saying and intending to reflect society's view.
But I thought Judge McLeese's question was going to a different point. Do we look at the impact and consequences as opposed to what the legislature is saying about the offense?
Yes, and I think they're both
objective. Both into account.
I think they're both objective because what the legislature, it's not just what the legislature is saying. I think what Judge McLeese posits is that it's actually doing something different. It's imposing a lengthier period of probation for a particular petty offense because they view it as particularly serious.
And just to give my hypothetical one other, to make it maybe a little harder, imagine instead that in a particular jurisdiction, every petty offense has a maximum sentence of 90 days. And imagine that the legislature takes one of them and amends that to make it 6 months, and the legislative history, and it's the only offense, that has a 6-month sentence. And the legislature says, we're increasing this because we view this as a very serious offense, not comparable to the petty offenses that we are, punishing by only 90 days. Would you say jury demandable because of the kind of rationale and contrast between the treatment of other petty offenses, or would you say not because you really need to look at objective impact?
I think that is a harder question because it is such, because there is a presumption in the Supreme Court case law that anything under 6 months or under 6 months or less is a petty offense. And then you have to look at additional statutory penalties that would sort of push it over the line. And there you have a period of incarceration that is fairly, that is farther away from that 6-month line than the 180-day offense, which by the way, I'll just point out that, when Blanton talks about how, and Blanton and its predecessors talk about how the period of imprisonment tells you a lot about how serious an offense is as regarded by the legislature. That's generally true, but in the District of Columbia, that's not true with respect to 180-day offenses versus offenses that exceed 6 months, because they were reduced to 180 days precisely for the purpose of avoiding a jury trial, and not because the legislature viewed them as less serious. So I think that's I don't know that has any formal place in the analysis, but I do think I do want to make I don't want to rest too much on this particular argument because I do think that there are two independent reasons or combined reasons that make sex offender registration, the penalty attached to sex registration offenses, that they reflect the council's determination that misdemeanor sexual abuse of a child or minor is a serious offense.
Can I ask you just a framework question as you move to that second topic?
Yes.
Am I right that the right way of looking at this from your perspective is that we need to figure out whether the maximum term of incarceration applicable to this offense, plus the period of probation that is available for the offense, which right now I can't remember off the top of my head, maybe you can remind me, plus the maximum fine available for the offense, which I also don't remember right now, but maybe you'll have at the tip of your fingertips, plus the SORA registration, plus the assessment. It's really all of the penalties accumulated together, whether they're sufficiently great, as sufficiently severe as to make this a jury demandable offense constitutionally. Is that right?
Yes, that's what Blanton says, and that's what Baudot says.
And can you remind me, do you know, I meant to look this up and I didn't. So can you remind me what the period of probation is and what the fine available is, if any?
The fine is $1,000. The victim compensation fund is, as Your Honor had mentioned last time, is $250. I don't have the probation period at my fingertips, but I think that sort of what we focus on, and this will segue to my second point, is that 10 years, a very long time compared to all of those things, of sex offender registration and community notification, which we think the notification part of it is what leads to such severe consequences in a registrant's life, that they kind of pale in comparison to most other collateral consequences, and that the government really doesn't dispute are severe.
So what do we call that? Do we class that as social stigma? I mean, is this kind of a Hawthorne Scarlet Letter situation? Is that the way we think about it?
Well, we think about it in a couple of different ways, and I'll break it down. I mean, one is a very simple one, just as a matter of invasion of privacy, just dissemination of personal information that otherwise wouldn't be available to the public. Second is, as Your Honor said, sort of social stigma. But then I think what we focus on most is kind of what does the social stigma mean? It's the practical consequences in terms of, the defendant's employment, housing, educational opportunities, social ties, psychological impacts, and that is all documented very heavily in the social science research and the body of literature that has built up in the 17 years since Smith versus Doe was decided.
I ask you how to approach those consequences, because some of them, though not all of them, seem implicit in the fact of being convicted for a child sex offense in and of itself. And now, is it your argument that assume a defendant could show that just being convicted of a child, if the name of your offense of conviction is, child, sexual assault on a minor or some equivalent, a bunch of bad things happen to you, you're very likely to get fired if your employer finds out about it, or maybe you're required to report that to your employer. And people, obviously, if they learn about it, are going to have an adverse reaction. Are all of those, assume a case like that, are all of those consequences that are implicit on the fact of conviction itself part of the severity analysis in your view?
Yes, because I think that the whole rationale of SORA is that
well, my question is again not about SORA.
People don't know about it.
Right. No, my question is not about
informed.
SORA. My question is not about SORA. My question is imagine we didn't have SORA here.
Oh,
I
see.
Your client was coming in and saying, look,
so no,
this is an offense. And my first question is not so about what the bottom line answer is. I'm just trying to figure out whether those consequences would count towards severity or whether they wouldn't.
I see. So I think that there's not a penalty. I mean, if the Blanton makes clear that a penalty has to be state action, it has to be a statutory or regulatory consequence. And so in your hypothetical where it's just a fact of conviction and when your employer finds out about it, they fire you, that isn't a state imposed penalty. Like the firing isn't a state imposed penalty. But what is a state imposed penalty is the community notification provision, which lets everyone know about this. And then that results in a lot of practical consequences that can be attributed to the state action.
Yeah,
why is it-
I have a hard time understanding the distinction between that and like, let's just assume that SORA doesn't exist. You get convicted of a sex offense, a misdemeanor sex offense, and there will be a target on your back when you go to jail. You're likely to be assaulted and in all sorts of horrible ways. Or let's assume some group of individuals at large and not the government is putting out a SORA-like database for everybody, so that there is still government action. It's the fact of conviction. The fact of conviction is what triggers all of those negative reactions to it. And so putting SORA as just an additional block in there, it doesn't seem to move the ball for me.
Well, what SORA does is that it's a penalty. I guess what I'm saying is that the conviction itself is not an additional penalty that I'm just trying to fit this into the Blanton framework. I mean, I think what Your Honor is saying might well be an argument one could make that is outside the Blanton framework altogether. You could say, penalty aside, the fact that I'm convicted of this crime makes me a target in prison, shows that society views this offense as serious. That would be, an argument you could make that is not foreclosed by Blanton necessarily, but that is not sort of within the Blanton framework. So with Blanton asks you to look at a penalty that is imposed by a statute, and in your hypothetical, there wouldn't be an additional penalty. I mean, the conviction is not a penalty itself. It's just a fact. It's not a penalty. And so I guess what we're saying that the reason that SORA fits into the framework, and it's different than what these hypotheticals that Your Honors are posing, is that it is an actual statutory requirement that is attached to a conviction that then leads to these very adverse consequences.
So if imagine a hypothetical that tomorrow the district passes a law that says when a defendant is found guilty of an offense in Superior Court, a criminal offense, any criminal offense in Superior Court, the trial court is required to serve the judgment on the defendant's employer, assuming the defendant's employed. Would you say that would make all otherwise petty offenses non-petty because that's a penalty and it creates a risk of discharge? Would you say it only makes some of them non-petty, and it would depend on the nature of the offense and the likelihood that an employer would react to that by discharging the defendant/employee? How would you analyze whether a provision like that made all or some offenses as to some defendants non-petty?
Sorry, so Your Honor's hypothetical is that there's a law that requires that kind of notice for every
just of the fact of conviction
for every conviction
for every criminal conviction in the district. Right.
So I think that would be certainly different than SORA in that it doesn't distinguish between serious and petty offenses. SORA singles out certain offenses as serious enough to require this additional monitoring and community notification, precisely because it views those offenses as serious and dangerous. Your Honors, I don't know what the rationale would be for Your Honors' hypothetical statute, but if the statute's purpose doesn't have anything to do with the seriousness of the offense, one might say that that penalty doesn't reflect the legislature's determination that the offense is a serious one. And then as to, I think that there would perhaps be another sort of factual question as to, sort of how likely is it that an employer would fire someone after finding out that they were convicted of a particular offense. I think we know from SORA, we know from the undisputed, literature that exists now that the employment effects are incredibly damaging for sex offenders. So I think that hypothetical, is very, very far afield from this situation, where not only do you have the legislature sort of picking out the serious offenses that it deems worthy of this sort of additional regulatory scheme that has to do with the dangerousness of the offense, the seriousness of the offense, but also the sort of just this incredibly widespread and well-documented phenomenon that as a result of this publication, people suffer very damaging consequences to many aspects of their lives.
Can I ask you how you
Gwen,
respond?
I have two questions I would like to ask you. One is, we're talking about the literature and what it shows in terms of the impact on people's lives. But can you compare that, for example, to the 5-year probation with conditions in Nactigal, where in a footnote, the Supreme Court lays out what some of those conditions might be? It didn't seem to think that that was enough to make it severe, and how that's different. And the other thing is, I'd like to go back to something that Judge McLeese asked you, which is that Blanton says, and Bado says, but we were just saying what Blanton said, that you aggregate everything, right? The potential maximum incarceration, in this case, 180 days, and you add this and that and the other and the other. And frankly, you kind of think intuitively that if you put all those things together on a scale, it would tip it, right? You would say, well, all those things together surely are grievous, are as grievous as one more day of incarceration, especially after you've already been there 180 days, right? But I don't get the sense that that's really how it's done. Can you point to any case where they really do a weighing of that kind?
So I don't have an example of, off the top of my head, of that type of case where that sort of aggregation. I mean, certainly all the cases say that's what you're supposed to do.
Right.
And that's kind of what we're stuck with. I mean, I don't really know what else to say about that other than that's the law. But as for to answer your Honor's question about probation, so the Supreme Court's in Nactigal, the 5-year probation period, that was not at all including. So the big difference between that probation period and SORA is that there's no community notification. So we agree that if it were just registration, if it were just telling the government, telling CSOSA where you live, that is akin to probation. Now it is 10 years, which is twice as long as the 5-year period in Nactigal. But in terms of the practical impact and why it's so detrimental, the real harm comes from the notification provision, because in probation, you don't have all of your information being posted on the internet, and you don't have all of the practical consequences of that publication. And so Nactigal really doesn't deal with that.
I get that point. I wonder what your view is of this aspect of what I take to be your opponent's argument. Franks and Nactigal together suggest that 180 days plus 5 years probation is not enough to make an offense non-petty. Cases like Smith in the Supreme Court and WM in this court say that sex offender registration, including with community notification, is less of a burden on the defendant than probation, and therefore, by almost mathematical calculation, sex offender registration has to not be enough to render an offense non-petty. Where do you think that line of reasoning goes awry?
I think it goes awry with Smith. So Smith does not say that so what Smith does say, applying the intent effects test, which asks whether a statute imposes a physical restraint or disability that would resemble punishment, because that's the question in Smith, is whether the law is imposing punishment. Smith says that the physical restraint of registration is less onerous than probation, and that's assuming no in-person reporting. Smith was careful to say we don't see any in-person reporting requirement here for registration, which is not the case in DC. And so Smith concludes as a result of that it doesn't resemble punishment, which is like, it's a different question. Smith does not say we're going to add up the impacts of the physical demands of registration plus all of the social impacts of notification and, all the privacy violations and the, housing and employment disabilities and all those. And then that's less onerous than probation. It certainly does not say that. What Smith says about the housing and employment impacts is that we don't see evidence that it's so widespread. The Court of Appeals identified one case where someone lost their job or housing after their information was put on the registry. And so we can't conclude that it's so onerous. And so what distinguishes this case from Smith is that now 17 years later, we have all of this evidence that's undisputed that it is widespread, that these kinds of impacts are widespread and onerous. And
do we have a sufficient record in this case as to what those impacts are in the District of Columbia, and does it exist?
Yes, I think we do. I think the government has waived any argument to the contrary because we raised all of those impacts in our jury demand. We cited one of the leading social science articles on the topic by J.J. Prescott from University of Michigan. We cited all of those articles in our main brief, and the government hasn't said ever that the record is insufficient. The government hasn't ever said, we don't see these kinds of impacts in DC. DC is somehow different from every other state in the nation with respect to these impacts. So, what Smith below, the government had actually filed two written objections to or oppositions to the jury demand, and nowhere did it question the record and the evidence. What it said instead was Thomas controls and SORA is not a penalty, which is what it says on appeal.
Can I just ask you? You said nowhere did the government question the evidence.
I'm sorry. When I said the evidence, is what I mean is nowhere did the government question the fact that SORA leads to these kinds of consequences. That was a factual assertion that defense counsel made in her pleading, citing social science research. And the government didn't come back and say, well, that research is flawed, or we don't have an evidentiary record, we should have a hearing on this. No one was disputing below the basic factual premise that community notification leads to these kinds of impacts, and that those impacts are
the government doesn't raise this, but in looking through the statute, the registration statute, I saw that the police department, the MPD, is supposed to conduct community education about the appropriate use of sex offender registration information. And there's also a provision that says that any publicly disseminated offender registration information shall contain a warning that crimes committed against sex offenders will be prosecuted to the full extent of the law. In other words, there seems to be some recognition that there could be adverse consequences on people that go beyond what is intended.
Absolutely. I think that the legislature very much knew that this was a likely consequence, and that's why it felt the need to warn people. And not only did they sort of foresee that internet notification could lead to crimes or harassment, committed against registered sex offenders, but the many of the very impacts we're talking about are an inevitable consequence of the purpose of notification, which is to allow people to identify sex offenders in their community and to avoid them. That is the very purpose of SORA, is to allow people to avoid sex offenders. So when you avoid sex offenders, you avoid hiring them, living in the same neighborhood as them, associating with them, going to school with them. I mean, that it may not be the purpose of the law, but it is absolutely, at least, if not intentional, I think intentional, but even if not intentional, at least highly foreseeable consequence of the notification provision, because protecting public safety by notification doesn't work unless people avoid the sex offenders. And so that is sort of part and parcel of this penalty. is social isolation, social avoidance, cutting off someone from the community.
Sort of assault, physically assaulting, committing a crime against such a person. Are there any protections under DC law that we could, at least in looking at kind of the objective indicia here of what was intended, you would say protect people? I mean, I take it no one
Not
is.
that I'm aware of, no.
No employers can ask this. For example, I understand that in New York City, you cannot ask a prospective employee about convictions, arrests, for let alone this specific one. But we don't have anything like that in DC, do we?
I'm not familiar. I'm not sure. I don't believe. I mean, I know that there is a nationwide movement to have those kinds of laws. I think that from a practical standpoint, it's not just, so there's two things. One is that, as we cited in our brief, there are examples of employers who would be willing to hire people, even if knowing that they had one of these offenses, but that in fact do not hire people because they do not want their business or their place of employment being associated with a sex offender on the internet. So that is
we
very
do
much
not have, as some other states, registration or SORA equivalents have, actual prohibitions on where people can live or
Right.
where they can work. Is that correct?
That's correct. Yes, that's
Okay.
correct. But then the other thing is that what SORA does that goes far beyond, what just a regular background check would do is what SORA allows people to do is just type in a particular street block, or even just look alphabetically through the list of the registry and just find out who the convicted sex offenders are that they never would have known about otherwise.
Let's take this out of the criminal context and put it in the sort of public health context and assume that there is some extremely infectious disease going around. Once you've got it for about 10 years, and you're likely to infect, if left to your own devices, 100 other people during that time, and a lot of people die, so it's pretty serious. And so we set up a civil system where anybody who's diagnosed with this disease is on a registry for 10 years for the purpose of people being able to avoid them, not having to interact with them. Is that necessarily a criminal punishment, given that it is so stigmatizing?
There's no crime. I mean, there's just no crime involved. So
let's just tweak it a little bit then and say, the legislature passes what amounts to a strict line to contract this disease becomes a criminal offense, punishable by no jail time or fines, but you need to be on the registry for 10 years. It's quite stigmatizing. No one's going to hire you. You're a carrier for a deadly disease. No one wants to.
You're hypothesizing that it's a crime to contract this disease, and
Sure.
that one of the penalties
To
is
be seen in public.
penalties is that you have to be on a registry, a public health registry.
Yeah. If you want to,
No,
ask
I don't
me
think
to-
that is, because I don't think I don't think that reflects the legislature's view that the crime is a serious one, in the sense of, I mean, it's a strict liability crime.
That's what I'm trying to get at. There's an argument that the government has, which is, it's not that this is such a horribly offensive human being, although, you could question that. It's that the risk of recidivism is particularly high with sex offenders, or at least that whether
Right.
that's true or not, set it aside. The DC Council might have thought so, and a lot of other legislatures might have thought so. That the recidivism risk is way too high. We don't mean this to be such a moral condemnation of the individual, but we need everybody to be on notice because they are, as in the public health scenario, they're super spreaders. They are at risk to, reoffend higher than any other type of crime. Assume the council thinks that. Would that necessarily be a severe penalty?
So I think that there's two things. One is that the council very much clearly said in passing SORA that it views sex offenses, especially against minors, as among the most serious offenses that there are, based on both the impact on the victim and the level of fear and concern that they generate in society. That is from the committee report that this court quoted in WM. So, I mean, I think that is, that clearly distinguishes SORA from Your Honor's hypothetical. And then secondly, I think it's very telling that the council hasn't chosen to create a registry for highly recidivist crimes that are petty. So package stealing is an extremely recidivist crime, probably. I mean, it's something that probably people, once you've done it, you probably, I'm sorry, my office lights went out. The motion detector was not, that it's, I would imagine, quite recidivist, but we don't have a registry for it, a 10-year monitoring for it, because it's not such, we tolerate package stealing, whereas we don't tolerate sexual abuse of children. That's something that is so bad in terms of what happens to the victim that recidivism, whether it's higher or lower, is a very serious concern for society. That is why SORA exists. And so the fact that the legislature attaches that consequence, attaches that penalty to the offense, shows us that the legislature views that crime as a serious one.
Thank you, Council. We're well over your time. We'll give you your 3 minutes in rebuttal, and we'll hear now from the United States.
Good afternoon. May it please the court, Christina Ament on behalf of the United States. In this case, appellant bears two significant hurdles in pressing this appeal. One is that being a petty offense, misdemeanor sex abuse of a child in this case is presumed to be petty. That's been stated by Blanton and many other cases. And it is the rare case in which appellant would be able to overcome that presumption. And the second hurdle is the controlling precedent here, that is Thomas, has already answered the question that is presented here, that is whether a sex offender registration transforms a petty offense into a serious one requiring a jury trial. And appellant, we would submit, has overcome neither of those hurdles. But given the nature of the argument that went before, and given the fact that it seems as though we are going to address this, I'd like to start by discussing the seriousness of this, of SORA registration, and the fact that it does not, it is not a serious enough sanction to transform this into a serious jury demandable offense. And as Judge McLeese indicated earlier, Frank and Nachtigal talk about probation, and SORA registration is very much akin to probation. In fact, it's a condition of probation. It's required of people who are convicted of these offenses to comply with the conditions of SORA, thus showing how interrelated it is with probation, but how it is a subset of the possible probationary term that is possible for this offense, and which the Supreme Court has said does not transform a petty offense to a jury demandable one.
Can I ask you, it seemed like what you just said was implying the view, and I'm just curious whether you're intending to imply it, that any lawful condition of probation, whatever it is, could never transform an otherwise petty offense into a serious offense, that it's just intrinsic, that as long as it's a lawful condition of probation, it just doesn't have the right form or character or severity. Is that what you're trying to say?
Your Honor, I would not go so far as to say that it would be impossible to come up with some condition of probation that wouldn't. But if we look at what Nachtigal and Frank talked about, those conditions were pretty serious. They were jail on the weekends. They were telling people where they could live. They were telling people whether they could work or that they had to work. All types of things that imposed restraint on how and where someone lived and how they conducted their lives to a much greater extent than the reporting requirements here do.
Can I ask you, no, go ahead.
I was just gonna, the jail on the weekends requirement was limited to 6 months, is that right? And that was presuming that no other jail time had been imposed. So
That's correct.
It's not like 5 years of weekend jail under Nachtigal, right? Am I remembering that right?
That is correct, but you could be 4 years and and 6 months into your probation, then have to serve that if the court modified the conditions to add it on.
Can I ask you about length of probation too? Because it's another possible implication of what you're saying, that probation is just not the right, sufficiently grave of a consequence to render an offense severe for this purpose. And I'm curious whether you think that's true without regard to the duration of probation. So if the legislature took a particular offense and said, to make it to make the hypothetical somewhat unappetizing, it took up an offense that had previously been a 5-year felony. And it said, we really don't want to have jury trials. We're going to reduce the sentence to 6 months or 180 days, more in line with our statutory provisions. But we're going to impose lifetime probation. Would you say just not severe? Probation, no matter how long, could combine with 6 months or less of incarceration to make an offense severe?
I think that's a harder case, Your Honor, but I still think that if the legislature were to say, we're going to change this into a 180-day offense, that we would start out with the presumption that the legislature had determined that the offense was petty. And we would then go on to say, is the kind of things that could be done for the lifetime severe enough to make the change, or severe enough to make it the rare case in which you could overcome that. And
so take Noctadal, for example, and the conditions that were at issue there. A lifetime under those conditions, you would say, would not entitle a defendant to a jury trial.
I would say that would be a harder case, Your Honor, and it might, but certainly it would be much less likely that even 10 years of it, which is what we're talking about here, 10 years of very, very fewer restrictions does not transform it. Those restrictions that SORA imposes, as the court said in WM, a defendant can live where he wishes, he can work where he wishes, he does not have to seek probation to leave or permission to leave the jurisdiction, et cetera. And so
what about the social stigma? I'm sorry to interrupt you, but I just wanted to, there's a different aspect of SORA registration that's been, that Ms. Wang is arguing, which is what I'll call generally social stigma and the consequences of that: social avoidance, impact of employment, education, possibly housing. That is something that the Supreme Court in Blanton, although it didn't think that it was sufficiently severe, in part because there wasn't a record in that case, seemed to think is something to be weighed in, in this whole calculus of whether a penalty is severe. What do you have to say about that part of this, given the nature of the offense?
Your Honor, first of all, we don't dispute the idea that a sex offense conviction, just like a DWI conviction or just like another conviction for soliciting prostitution, which is a petty offense in DC, all entail social stigma, the fact of conviction. And we would submit that they did that before there was sex offender registration, and they will do that whether sex offender registration continues or not. And the marginal difference between the amount of social stigma that's added by the notification requirements isn't enough by standing by itself to transform what is otherwise determined to be a petty offense, to overcome that presumption and make it the rare offense.
I'm curious why you call it a marginal difference when it really is the cart, it's the horse driving the cart. Registration is why people know about this, but just to take that out of the hypothetical, let's assume that instead of SORA, it's a 10-year requirement that a sex offender wear a bright orange shirt that says child rapist on it. No physical restraint. So it would be fair, like we have previously said, to say that doesn't involve the same physical restraint as probation. But maybe would you consider that A, a penalty, and B, severe under the Blanton analysis?
I think it's much closer to a penalty under the Blanton analysis because it's more akin to a shaming, which all the courts have been careful to say that registration is not the same as the type of shaming offense like chain gangs or the pillory in ancient times.
Courts have been careful to say that. I mean, explain to me how that's true.
It's simply because it is not saying that every time you walk out of your house in public, or it's requiring you to be placed in a public circumstance where people can approach you, ridicule you, stone you, et cetera, which were the types of things that things like the pillory and stocks were intended to promote. This, by contrast, is simply the dissemination of truthful information should somebody choose to find it. And just like maintaining a database that shows who's been convicted of what in DC that can be accessed for purposes of a background check, the mere fact that the information can be disseminated is much different from forcing somebody to walk around advertising that it applies to them. And the
Okay, so I get your point that it's different, but I'm not sure I got I picked up a clear answer to the hypothetical. Do you think that if a statute did require that, it would constitutionally entitle people who are potentially subject to that penalty to a jury trial?
No, Your Honor, I don't, because again, it's not a severe enough sanction to transform a presumably petty offense. Remember, we're going to rare case land here, and I would submit that requiring them to wear something like that, although it would be worse, more severe than what we're talking about here. Don't get me wrong, but I don't think that one would be. And
can I ask
certainly,
you your response? Your opponent has kind of a second line of argument that you haven't so much focused on about severity. You've been focusing thus far appropriately as an aspect of your opponent's argument about kind of the actual impact on the offender. But your opponent's first point was really there are other objective indicators of severity that relate to penalty that include things like, what are the other offenses that carry a similar punishment, something that the court thought was important in Noctegal, Supreme Court thought was important in Noctegal. And just to give you another example, you could imagine that the legislature expressly includes the offense in question as among serious offenses. It kind of labels it serious offense. Do you think those are potentially relevant, or do you think it's all irrelevant? And the only question is, what are the practical impacts of the additional consequences, assuming for the moment we're calling them all penalties and treating them as such, on the offender?
I'm not certain I understand your question, but I'll take a stab, which is
well, here,
that
I'll try to make it more concrete. But so here's an example. Your opponent says, here's an important thing to consider about whether this is a severe penalty. Every other Class B registration offense is at least a 5-year felony. Do you think that's irrelevant because it doesn't change the practical impact of the adverse consequences on the offender? Or do you agree that it is relevant and you just don't think it carries the day?
I think that what the legislature has said about offenses in the grand scheme of things is relevant. But I think that, as Blanton teaches, the best way to sort of look at what the legislature has done is to say, look, we're assigning a maximum prison penalty of 180 days, which is, 2 steps lower than what the Constitution says makes something petty. And we can look and see, well, what other things does the legislature assign that? And what other things does the legislature deem to be felonies and assign a much higher prison term? And we do that, and that's what Blanton instructs us to do. But to say that, for example, because a 5-year term of probation could be assigned in one of these serious cases, and it could also be assigned in one of the petty offense cases, that doesn't necessarily say anything about whether the legislature thought those were, deemed those equally serious.
Can I
It
ask you,
just said-
here's another way of getting at the same topic. This is obviously a ridiculous hypothetical, but imagine that the legislature tomorrow passed a statute and made first-degree murder a 180-day offense with, all sorts of registration requirements and, lifetime probation. Would you say that would be a petty offense? Or do you think it's relevant that it's just hard to get out of your mouth the sentence, murder is a petty offense, murder is a, not a serious crime? Would that be relevant or irrelevant? And how do you think that hypothetical should come out about whether you'd have a jury trial right?
I would say, Your Honor, that for the reasons that you just said, to get 3 judges or a city council to actually utter those words, murder is a petty offense, would probably be enough to overcome the presumption that something that 180 degrees is petty. And we could say,
your opponent argues that and maybe you'll get these words out of your mouth, I don't know. But your opponent's argument is, I dare you to say sexually abusing children is a petty offense. So, and the legislature didn't say that. In Sledges of History, it said the opposite.
Well, Your Honor, what the legislature did say was that child sex abuse writ large was serious. However, in fashioning penalties, the legislature distinguished between the misdemeanor version of that and the felony versions of that by.
Okay, I get your
But
point.
in Bado, for example, in Bado, where we also had misdemeanor sexual abuse of a child, we did look to how the Congress characterized this offense, calling it an aggravated felony. Now, we could set aside, okay, it's a label because that triggers other, sections of the Immigration Act. But we did point out that the other aggravated felonies that the Congress identified were extremely serious felonies. And they included misdemeanor sexual abuse of a child along with those. And, we have this notion that when you look at, it's a principle of statutory construction that you kind of take some meaning from those things that surround a particular word or a certain classification. But it's pretty clear that the Congress in that case thought that it was on a par with those very, very serious felony offenses, such that it would trigger conviction of that offense would trigger the same immigration consequence, deportation. So why wouldn't that be the same type of analysis we would conduct in this case in terms of what the council said and the fact that it classed this offense along with other Class B offenses, which have more serious incarceration penalties?
Well, Your Honor, first off, I think it would be a very dangerous road to go down the road of trying to import what Congress has said in the immigration context to much of anything. And so,
we've done it.
Other than the fact in Bado, this court had to do that because this court had to figure out whether the appellant faced deportation. But to say that because Congress has said something in an immigration context, we can just import that willy-nilly, to me makes no sense, and I think would create all kinds of unforeseen problems, just given the sort of crazy quilt way that the immigration laws are written and enforced, particularly right now. But turning to the question, what that you're asking is that I think that the council hasn't said, if the council actually had found that the conduct that was charged here was serious, it wouldn't have created the offense of misdemeanor sex abuse of a child. So I think by definition, the council has said there are degrees, and some of them are presumptively petty, i.e. a possible sentence of 180 days.
Counsel,
Um,
what if we had a clear either legislative history or even sort of a prefatory comment to the legislation that said, seeing as how felony child sexual abuse can be quite tough to prosecute, we create a misdemeanor sexual abuse to get around the jury trial right. And in order to do that, we need to make it punishable by only 180 days. So that it was absolutely clear it did not reflect any lack of severity in the crime, but instead made clear that the legislature's intent was to get around the jury trial right. Would that kind of record lead to the conclusion that it is still a severe penalty?
No, Your Honor, I don't think so, because I think what Blanton says is that the best way to understand what the legislature really means is serious, is the best way is to look at the maximum prison term.
Although
And-
I think the hypothetical just is constructed in a way that says, well, maybe that's generally right in Blanton, but what happens when we know it's wrong? Follow Blanton blindly? Or does Blanton leave room to say, you know, there is some room for chicanery in this rule, and we don't let it slide when it appears it's happening?
Well, first of all, Your Honor, before I even answer that question, I'm assuming that you are asking a hypothetical and you're not asking me to comment on whether I think that's what went on in this case.
Correct.
But seeing as how it's a hypothetical, again, Blanton does say that it is the rare case. And so but what Blanton really was talking about there is that it's the rare case that something with these minor penalties would in fact be transformed into something serious enough for a jury trial right. And so I think that it's difficult to imagine a principle that would allow this court to rule, and given this line of cases, that somehow chicanery, as the court calls it,
Just
which
strategic
essentially
thinking about that.
diminishes of the consequences of a case to the point where everybody has decided that, or where historically, since I don't even remember when, has decided that there are presumptively petty offenses that don't require a jury trial right. And I don't think that the idea that somebody has said, well, we don't want to have jury trials in these cases, is somehow transform or leaves the case where once the council has held that and transformed the penalties accordingly, we can say, well, you are entitled to a jury trial because they were kidding. And that's essentially what I think you're saying. So I don't think that if the council has said, we don't think this should be jury demandable, we're lowering the consequence because these cases, because we don't want to convey a jury trial right, and we're going to lower the consequences accordingly. So no matter how bad you are, you can't get more than 180 days for whatever it is you did. I don't think that there's room to say, well, that's really a severe case because
That
we don't
seems,
like.
that answer seems a little bit in tension with the answer you gave in the hypothetical about murder. Because I thought you said some offenses, given their history and their kind of everybody's understanding of their gravity, would be such that whatever penalty the legislature ascribed to it and whatever reason that the legislature gave for ascribing that penalty, it's just so, there's just no way of escaping the conclusion that it's grave criminal conduct and you shouldn't treat it as petty. Constitutionally, and that would be yet another mode of analysis filling out the idea in Blanton that there's a presumption, that's focused on the amount of incarceration, but that's not the only inquiry.
Well, Your Honor, I believe that the difference is that in your hypothetical, you said there would be a massive amount of registration and other requirements and lifetime probation for the offender. And so therefore, we're looking at a series of punishments and asking whether those overcome the presumption of petty. Whereas
that's a fair response.
Judge,
Can I just ask you, I wanted to wrap back to one thing, because I want to make sure I understand your position. You said something suggesting that you thought that the at least misdemeanor sexual abuse of a child isn't really grave criminal conduct. And I want to make sure I, don't misunderstand the United States' position on that. The conduct that Mr. Fallon was convicted of here, which involves for his own gratification, touching a child in various either clothed but private areas of her, or having her put her hand on his clothed genitalia. Is it your position that that's not serious criminal conduct?
Your Honor, I think it's extremely serious criminal conduct, but I think what the council has said is that it is within the range of misdemeanors. Just like I would say that if somebody walks up to me and punches me in the face, or kicks me in the stomach, or I believe, as the court talked about, takes my head and slams it against faucet fixtures, those are serious conduct too. But they've wound up being classed in a group of misdemeanor offenses. So what I'm saying is, when I talk about grave criminal or serious criminal conduct, I'm saying within the legislative meaning of that. In other words, the council has said some aspects of child sex abuse are misdemeanors, others are felony, and that's their determination, and the penalties are ascribed to them in relationship to the determination of how serious the council found those things to be.
Well, I know we're also, I think, a fair bit over your time. I want my colleagues get a chance to ask any further questions they have. And if you want to wrap up in a sentence or two, or if you're finished, whichever you prefer.
Thanks. I would just say to the court that we haven't gotten to discuss it, but Thomas still controls this case, and council has not overcome, appellant has not overcome that hurdle, and appellant has not shown any reason has not overcome the presumption to show that this is the kind of rare case or rare situation in which a petty offense has been transformed for constitutional purposes into a serious one. And for those reasons, we would ask that the judgment below be affirmed.
Thank you, counsel. Ms. Wang, we'll give you your 3 minutes in rebuttal, if I recall correctly.
Thank you, Your Honor. I think it helps to put the Sixth Amendment jury trial jurisprudence in historical context, which is that prior to, this whole focus on the severity of the punishment or the penalty, the Supreme Court looked to see whether a particular crime was jury demandable, or determined whether a crime was jury demandable based on its common law analog, and whether it was considered serious at common law, and whether it deserved a jury trial. And then later, when there were crimes that didn't have common law analogs, there were just judges deciding whether these were serious crimes. And that's what the Supreme Court was reacting to when it developed this objective method for determining whether something is serious. So it was not saying that, looking at the severity of the penalty is always the best way of determining whether a crime is serious. It was just a better and more objective way compared to, judges opining. And so when you do have in a situation like this, when you have very clear objective evidence that the legislature views a crime as serious, attached to the penalty, mind you, not just, from a stray line from legislative history, but it's actually built into the structure of the penalty, such that the legislature is classifying an offense in a particular way that is that warrants a greater penalty than other crimes. So not every sex offense is a registration offense. Misdemeanor sexual abuse of an adult, while I'm sure everyone would think that, sort of in common parlance is a serious offense, is not determined to be serious enough to be a registration offense.
I just want to read you a sentence from Blanton and get your reaction to it, because I think it contradicts a little bit of what you just said, which is, it says when the maximum punishment is less than 6 months imprisonment, a defendant is entitled to a jury trial in such circumstances only if he can demonstrate that any additional statutory penalties viewed in conjunction with the maximum authorized period of incarceration are so severe that they clearly reflect legislative determination, et cetera. That's at page 1293, but I'm not sure if that's the right pin site to give you, 543 as well. And I read that because, I mean, that seems to contrast with your view that, we really, Blanton and Noctegal were kind of a departure from this prior way of looking at things, and there's some residue of that left. It doesn't look like there's any residue of that left. It looks like we're only looking at the penalties that attach because that's what Blanton says. Is that
I agree that you
is
do
wrong?
look at the penalties, and Blanton also says we have found the most relevant of the criteria in the severity of the maximum penalty. It doesn't say it's the only one. But I guess my point is that it's,
Yes.
my
Okay,
argument is that
the sentence that I read says only if he can demonstrate severe penalties. So I mean, I agree. There's some other language in Blanton that isn't quite so strong, but that sentence seems quite strong.
well, I don't think I would be making the same argument if it was just a sentence from the council report saying this is a serious offense. My argument is that the penalty of sex offender registration, by its structure and purpose, is tied to the severity of the offense. That the council picked out sex offenses as the type of offense that needs additional 10 years of monitoring and community vigilance because of how dangerous and particular it is. And then looked at all the sex offenses and said, some of them are not going to be worthy of this type of intrusion and costly measures. Some, like misdemeanor sexual abuse of an adult, are not. And so the penalty is tied only to serious offenses. That, I think, looks at the severity of the penalty and whether it reflects the seriousness of the offense. That's still consistent with Blanton. And the Arizona en banc court in Fushek.
Can I understand your just another hypothetical? I apologize for having so many of them, but here you go. Imagine that tomorrow the legislature passed a statute called the Serious Offense Enhancement Act, and it added a $5,000 fine penalty payable to a compensation fund. And the legislative history was, there are a number of serious crimes, and the victims of them aren't allowed to get adequate, they can't get restitution adequately, and they need support. And there were a bunch of offenses included in it, and they're all 5-year felonies or worse, and then misdemeanor child sexual abuse. Would you say, $5,000 penalty in isolation doesn't sound that severe? So by itself, in ordinary circumstances, wouldn't be enough to tip the balance to make something constitutionally serious for this purpose. But because this particular enhancement was applied only to offenses the legislature described as serious, all the others of which are constitutionally serious by their terms of incarceration, misdemeanor sexual abuse should, by its inclusion in that list, become serious. Is that kind of the mode of analysis you are recommending to us, that that's independent of kind of the objective impact on the defendant, which may be modest or not enough by itself? These other circumstances tell you something about the severity viewed from perspectives other than impact on the defendant? Is that what you're getting at, or am I missing your line of thinking?
So I think that hypothetical presents a more difficult case because it does run up against the holdings of the Supreme Court saying that $5,000 is not severe. And we don't have a holding from any binding precedent saying that 10 years of sex offender registration and community notification are not severe. So, but I take your point, and I think that it is, that's a difficult case. And I think that it would, the objective evidence of the legislature's view of the seriousness of the case, would present, I think, a really difficult question as to how useful the sort of pure severity analysis is, and whether the court should continue to sort of blindly follow it when it doesn't make sense. That's not the case here. And I think the Arizona en banc court in Fushek applied Blanton, but it looked to the purpose and structure of its version of SORA and said something very similar to what we're arguing here, which is that and I'll quote, "The statutory requirements of warnings to various communities about the identities and presence of sex offenders confirm that the legislature views sex offense as serious crimes. Indeed, almost all the other crimes for which sex offender registration is authorized or required involve felonies, recidivist behavior, or crimes against children. The authorization of registration for misdemeanors involving sexual motivation strongly suggests that the legislature views such crimes as similar to these other plainly serious offenses." So another court applying Blanton did this very same thing that we're talking. So no, granted, Fushek also looked at the severity of the actual penalty. It talks about, how it's, a lengthy period of registration, that it causes a lot of disabilities, and granted, the particular requirements of SORA in Arizona were more onerous than in DC. But an important mode of its analysis was looking at these other objective indications that the legislature viewed these sex offenses as serious. So I think that it's, I don't think this case requires the court to pick one mode of analysis over the other necessarily, because I think both strands of reasoning lead to the same result. And they both are consistent with Blanton because they both look at what the penalty says about the seriousness of the offense as viewed by the legislature.
Thank you, counsel. Unless my colleagues have any further questions, we thank both parties for their briefs and their arguments today, and the case is submitted.
This court is now adjourned.